So employers involved in pending PAGA cases, what should they do? Leading up to Viking, we were getting some stays of the cases. And now that we do have Viking that's out, a lot of employers are bringing motions to compel arbitration if the plaintiffs aren't agreeing to drop the PAGA cases. No, we are seeing some plaintiffs push back on these motions to compel arbitration, saying that there's arguments on why the arbitration agreement is not enforceable. And here's on this slide some common arguments that come up in litigation. We're seeing it all the time. If it's a Spanish-speaking employee, they'll say it wasn't translated for the employee didn't understand the agreement, things to that effect. So consider translating the arbitration agreement. Electronic signatures, need to be careful about that. I generally do like electronic signatures on the agreements. It's easier generally to prove that the employee signed it, but be ready to explain how that process is handled with the employee. And once the electronic signature is obtained by the employee, how that's stored. You're going to have to explain that to the judge to make certain that you can set out that chain of when it was provided to the employee and how it was signed and how the employer maintained that document. It often comes up that the employee says, I don't remember signing it, or that wasn't my signature. So you need to have that process in place on how to be able to explain that to the judge. Also, we generally don't like having arbitration agreements in employee handbooks. These have been challenged recently. This Mendoza versus Trans Valley Transport is a key case on that. Generally, there's a lot of language in employee handbooks that says this is not a contract with the employee, and the employer can modify it at any time. And then you put the arbitration agreement in there. It basically nullifies that arbitration agreement in the employee handbook. So be careful about that. I generally like standalone arbitration agreements for a number of reasons. Also, I don't like putting the entire employee handbook into a public record when you're trying to enforce an arbitration agreement, because all of your policies are now out there for everybody to look up in the public record. I generally rather only have the arbitration agreement in the record when you're going in to bring a motion to compel the arbitration. Also train your supervisors and HR about the agreements, how to handle them, how to handle questions about them, how to handle objections to them. Are they going to be mandatory or not? And I'll talk about that here in a minute too. And then have just a process set up. Really think about this, how you're going to process, store, and retrieve these arbitration agreements. And need to track who signed them and who hasn't signed them. It comes up all the time in litigation when we do get a class action or a PAGA case, and we have to pull these agreements going back potentially 4 years, and they're in paper files, individual employee personnel files in paper. It takes a long time to go back and find those, and it's likely to get missed or lost too, some of those. So think about it, how to store those electronically. Again, I like that, and how to retrieve them as well. Now, if you've got a current pending case, pending class action or a pending PAGA case, it's a little trickier on how to get employees to sign arbitration agreements with waivers in there. It's not impossible, but you need some help from legal counsel to do that. And then also it just needs regular legal review.